The effort to build more housing across California that is focused on removing the obstacles thrown up by local governments. And now the U.S. Supreme Court has ruled that cities and counties must be more judicious in the way they assess impact fees on development projects.
John Ramos explains how that could affect what's being built.
The ruling stemmed from a case called Sheets versus El Dorado County, in which a man wanted to put a modular home on his property and was told he had to pay to replace the entire street. Well, the Supreme Court says that wasn't proper, and now it may be a game changer in the housing crisis. Efren Carrillo understands how that man in El Dorado County felt. Here in Santa Rosa, Carrillo was involved with the development of this affordable senior apartment complex on the site of a former mobile home park destroyed by the 2017 Tubbs fire. But the amount the city charged to do that is simply astounding.
Had an average of $40,000 to $60,000 per unit on impact fees. That is money that can be going into building additional housing and residential units for working class people.
Impact fees are the assessments developers must pay for the added burden to the community, streets, utilities, parks, etc. Officials are supposed to study what those impacts are, but they often just assign an arbitrary fee per unit on the projects. And the money collected doesn't even have to be spent in that area.
So it helps pay for parks in other communities, streets improvement in other communities, which is fine. It's just a function of right-sizing what that impact is on the development that you're proposing.
But that's what the Supreme Court said may be unconstitutional. The unanimous ruling said the fees charged must be connected to and roughly proportionate to the actual impact of the development. Jen Close with the Santa Rosa advocacy group Generation Housing says builders now have the power to challenge the validity of local impact fees in court.
And I think that that's what Sheets is going to ultimately require, is that those examinations are a whole lot more specific and more careful. Otherwise, they're going to find themselves defending lawsuits.
Developers have been insisting for years that impact fees are having a stifling effect on new home construction, and that is borne out at the senior complex. 2 phases of the project are complete, but financing for the 3rd phase simply isn't there, and the land next to it sits vacant.
With high development impact fees or impact fees that don't make sense, developers leave the state. They're building in Nevada, they're building in Texas. We think that by right-sizing impact fees, by modifying them, builders can come back to California and build the units that we need.
It will be a hit to local government budgets, but it may be the trade-off required to build the housing they're asking for. Carrillo just wishes they would stop acting like building houses is somehow harming the community.
You would think that building housing and affordable housing would not be seen as an actual impact on the community. There's a little irony in that we're trying to build workforce housing and affordable housing, and yet we're considered an impact.
The ruling didn't define what fees constitute a taking of private property. They're leaving that for the lower courts to hash out. But Jen Close says cities may save themselves a lot of legal costs if they simply cut their fees voluntarily.
And a state law passed in 2022 requires local governments to make the fees more proportional, but it gave them 8 years to study the true impacts. The Supreme Court ruling may hurry that process by exposing them to lawsuits from developers.